हेलो दोस्तों, आप लोगों का स्वागत है हमारे चैनल टेक लॉयर्स पे। आज हम लोग बात करेंगे भारतीय नागरिक सुरक्षा संहिता BNS। सो BNS में क्या नया आया है। आज हम लोग देखेंगे व्हाट इज द न्यू थिंग्स एडेड इन BNSS। ओके, अगर आप देखते हैं BNSS इज BNSS is 46 of 2023 and going to enforce from 1st July 2024। जो भारतीय नागरिक सुरक्षा संहिता है 1 जुलाई 2024 से ये एक्ट एनफोर्स होने वाला है। ओके, एंड नंबर ऑफ सेक्शंस इसके अंदर दिए गए हैं 531 एंड जो टोटल नंबर ऑफ चैप्टर है V39 दिए गए हैं। हावेवर अगर हम बात करें CRPC की, जो इससे पहले क्रिमिनल प्रोसीजर कोड था, उसमें जो सेक्शन थे वो 484 थे टोटल नंबर ऑफ सेक्शन, एंड टोटल नंबर ऑफ चैप्टर 37 थे उसमें। ओके, नाउ हम बात करते हैं कि व्हाट इज द न्यू थिंग्स एडेड इन BNSS, भारतीय नागरिक सुरक्षा संहिता में नया क्या जोड़ा गया। स्टार्ट करते हैं डेफिनेशन क्लॉज से। तो डेफिनेशन क्लॉज में सबसे पहले जोड़ा गया 2(1)(a) ऑडियो वीडियो इलेक्ट्रॉनिक मीन्स। अब हम लोग बात करते हैं कि इसकी क्या डेफिनेशन दी गई है। ऑडियो वीडियो इलेक्ट्रॉनिक्स मीन्स audio video electronics means shall include use of any communication device for purpose of video conferencing, recording of process of identification, search and seizure or evidence, and transmission of electronic communication, and for such other purpose and by such other means as the state government may be rule provide। इसमें आपकी जो इलेक्ट्रॉनिक मीन्स है इनको इंक्लूड किया गया। दैट इज अ न्यू डेफिनेशन एडेड अंडर सेक्शन 2(1)(a। नाउ देयर इज अनदर डेफिनेशन व्हिच इज एडेड। नाउ द 2(1)(b) इज अ बेल। बेल की डेफिनेशन दी गई है। लेट्स सी व्हाट इट इज। बेल मीन रिलीज ऑफ ए पर्सन अक्यूज्ड ऑफ और सस्पेक्ट ऑफ कमीशन ऑफ एन ऑफेंस फ्रॉम द कस्टडी ऑफ लॉ अपॉन certain condition imposed by an officer or court on execution by such person of a bond or bail bond। इसकी डेफिनेशन दी गई है यहाँ पे कि बेल की क्या डेफिनेशन है। किसी पर्सन को सर्टेन कंडीशन के द्वारा एक ऑफिसर रिलीज करता है। एंड नाउ 2(1)(d) दैट इज अ न्यू डेफिनेशन एडेड इज अ बेल बॉन्ड। बेल बॉन्ड की क्या डेफिनेशन दी गई। बेल बॉन्ड मीन्स एन अंडरटेकिंग फॉर रिलीज विद श्योरिटी। And now there is another definition 2(1)(e) bond। bond की definition, bond means a personal bond or an undertaking for release without surety। That's all definition, and one more definition which is added 2(1)(l) is a electronic communication। I think is a 2(1)(i). Okay, electronic communication। Electronic communication means the communication of any written, verbal, pictorial information or video content transmitted or transferred whether from one person to another or from one device to another or from a person to device or from a device to a person by means of an electronic device including a telephone, mobile phone or other wireless telecommunication device or computer or audio video player or camera or any other electronic device or electronic form as may be specified by notification by the central government। This is the new definition which is added। Now apart from that, now there is one new section which is added 35 clause 7। 35 clause 7 में क्या बात करते हैं। when police may arrest without warrant। 35(7) भी हम लोग देख लेते हैं। मैं आपको स्पेसिफिकली बता देता हूँ 35(7) में क्या लिखा हुआ। No arrest shall be made without prior permission of an officer not below the rank of deputy superintendent of police in case of an offence which is punishable for imprisonment of less than 3 years or such person is infirm or in above 60 years of age। Okay, this is the new section which is added, like when police may arrest without warrant। Okay, now there is a under section 86 which is newly added in this definition। Now let's see section 86 what is talk about। Section 86 is identifications and attachment of property of proclaimed person। What it say, like it's a newly added in this, the court may on the written request from a police officer not below the rank of superintendent of police or commissioner of police, initiate the process of requesting assistance from a court or an authority in the contracting state for identification, attachment, or forfeiture of property belonging to a proclaimed person in accordance with the procedure provided in chapter 8. So this is section 86. Now one new section added, that is 105. So what is 105 talk about? Let's see. 105 is a recording of search and seizure through audio, video, electronic means. So audio, video, electronic means, like 105, like the process of conducting search of a place or taking possession of any property, article, or thing under this chapter or under section 185, including preparation of list of all things seized in the course of such search and seizure and signing of such list by witness, shall be recorded through any audio, video, electronic means, preferably mobile phone, and the police officer shall without delay forward such recording to the district magistrate, subdivision magistrate, or judicial magistrate of the first class. Okay, so under section 105 में ऑफिसर रिकॉर्ड करेगा रिकॉर्डिंग को और वो डिस्ट्रिक्ट मजिस्ट्रेट को और आपके जुडिशियल मजिस्ट्रेट को वो रिकॉर्डिंग सेंड करेगा. नाउ 107 which is a newly added section, attachment or restoration of the property. So attachment, forfeiture and restoration of the property, where a police officer making an, so 172 is talking about person bound to conform to lawful direction of police. So all persons shall be bound to confer to the lawful direction of a police officer given in fulfillment of any of his duty under this chapter. And subclause 2 is talking about a police officer may be detained or remove any person resisting, refusing, ignoring, or disregarding to conform of any direction given by him under subsection 1 and may either take such person before the magistrate or in PT cases release him as soon as possible within a period of 24 hours. So इसमें क्या है कि person bound to conform to the lawful direction. अगर कोई पुलिस ऑफिसर आपको lawful direction देता है तो you must have to comply with the same. आपको वो पुलिस वाले की direction को follow करना होगा. Otherwise he can detain you and he can produce you before the magistrate. Okay. Now under section 336. Okay, that is newly added section. Evidence of public servant, expert police officer in certain cases. So what is talk about in this under section 376? So 376 is talk about like whether any document or report prepared by a public servant, scientific expert, or medical officer in purpose to use as an evidence in any inquiry, trial, or other proceeding under the Sahita, and such public servant, expert, or officer is either transferred, retired, or die. Such public servant, expert, or officer cannot found or incapable of giving deposition or securing presence of such public servant, expert, or officer is likely to cause delay in the holding of inquiry, trial, or other proceeding. The court shall secure presence of successor officer of such public servant, expert, or officer who is holding that post at the time of such deposition of giving deposition of such document or report, provided that, okay, इसमें provision में लिखा है, provided that no public servant, scientific expert, or medical officer shall be called to appear before the court unless the report of such public servant, scientific expert, or medical officer is disputed by any of the parties of the trial or other proceeding. Provided further that the deposition of such successor public servant, expert, or officer may be allowed through audio, video, electronic means. That's mean like any medical officer or public like expert give his opinion in the case and he is not able to produce before the court, or maybe he died. So any successor of his, like he can produce before, like he can come before the court through the audio, video conferencing, like electronic means. So उसके थ्रू वो आके अपनी डेपोजिशन दे सकता है. Okay, this is a newly added section. section 336. Now section 356, inquiry, trial or judgment and absentia of proclaimed offender. So what is 356 is talking about? Under section 356 is notwithstanding anything contained in this Sahita or in any other law for the time being in force, when a person declared as a proclaimed offender, whether or not charged jointly, has absconded to evade trial, and then there is no immediate prospect of arresting him, it shall be deemed to operate as a waiver of the right of such person to be present and tried in person, and the court shall, after recording reason in writing in the interest of justice, proceed with the trial in the like manner as the like effect as if he was present under the Sahita and pronounce the judgment, provided that the court shall not commence the trial unless a period of 90 days has lapsed from the date of framing of charges. So इसमें क्या बोला गया है कि जो ट्रायल है, अगर कोई जो ऑफेंडर है, ही इज अ प्रोक्लेम ऑफेंडर, ही इज लाइक एविक्टेड और वो वहां पे नहीं है, तो इन दैट सिनेरियो आपका जो ट्रायल है वो कैसे इंक्वायरी कंडक्ट होगी और कैसे फर्दर ट्रायल को कंप्लीट किया जाएगा. सो ये सब चीजें इस सेक्शन में डिस्कस की गई हैं. Like okay, now we are not going to dive into the section. Okay, like I just give you the brief overview about this section. Now section 398, witness protection scheme. So in 398 like witness को protection दी गई है. So इस section में क्या बोला गया है 398 में? 390 is like every state government shall be prepared and notify a witness protection scheme for the state with a view to ensure protection of the witness. So यहाँ पे बात की गई है कि 398 में कि आपके जो विटनेस हैं उनको प्रोटेक्शन दी जाए. Okay, like section 398 of the Bhartiya Nagrik Suraksha Sahita relates to witness protection scheme. It provides to every state government shall prepare and notify witness protection scheme for the state with the view to ensure protection of the witness. So इसमें यही है कि स्टेट गवर्नमेंट रूल बना के मेक श्योर करे कि जो विटनेस है किसी भी केस में उनको प्रॉपर प्रोटेक्शन दी जाए. ओके, नाउ सेक्शन 472, मर्सी पिटिशन इन डेथ सेंटेंस केसेस. सो जो 472 में ये नया सेक्शन ऐड किया गया है, इसमें जो बात की गई है कि a convict under the sentence of death or his legal heir or any other relative may, if he has not already submitted a petition for mercy, file a mercy petition before the President of India under Article 72 or Governor of the state under Article 161 of the Constitution within a period of the 30 days from the date of which the Superintendent of the jail. सो आपके जजमेंट प्रोनाउंस होने के 30 डे के अंदर अगर किसी को डेथ पेनल्टी हुई है तो इन दैट सिनेरियो जो कन्विक्टेड या उसके रिलेटिव या उसके लीगल हायर कोई भी मर्सी पिटिशन विद इन 30 days बिफोर द प्रेसिडेंट ऑफ इंडिया, बिफोर दैट लाइक ही हैव टू फाइल द गवर्नर ऑफ द स्टेट अंडर आर्टिकल 161 वो फाइल करेगा. So in this section, they are talking about the mercy petition. Now 530, trial and proceeding in held in electronic mode. So ये section भी नया added हुआ है जो कि बात करता है 530 कि all the trial, inquiry and proceeding under the Sahita including issue, services, execution of the summons and warrant, examination of the complainant and witness, recording of evidence in the inquiry and trials, and all appellant proceeding or any other proceeding may be held in electronic mode by use of electronic communication or use of audio video electronic means. That's mean 530 is talking about कि आपका जो पूरा ट्रायल है वो इलेक्ट्रॉनिक मोड पे हो सकता है, लाइक जो विटनेस का एग्जामिनेशन है या फिर जो इशू करना है समन सर्विसेज, एवरीथिंग कैन बी डन ऑनलाइन. Okay, so this is the new section added and this is all about it. What is the newly added in this BNSS. So if you like the video, please like, comment, share and subscribe the channel. Thank you.